The issue of war crimes has been raised once again since Azerbaijan's major attack on Armenia proper in mid-September. A video showing Azerbaijani soldiers gunning down a group of Armenian POWs gained much attention and was verified by a group of Dutch investigative journalists. The international courts are one avenue that several Armenian legal teams have been pursuing. To discuss this and more, I'm joined by Yeghishe Kirakosyan, a lawyer and the designated Armenia representative at the International Court of Justice in The Hague. So Mr. Kirakosyan, thank you very much for your time.
Thank you.
So there are two international courts which are being pursued by Armenian legal teams, the International Court of Justice and the European Court of Human Rights as well. On top of these two, there is also talk at the moment about the International Criminal Court. I want to talk a bit about that first. What do you think when we hear talk about recognizing the jurisdiction of the court, ratifying the Rome Statute, and becoming a full member? I mean, what do you think when we hear talk of this?
That's a very complicated issue. Of course, if you look back, Armenia is a signatory state to the ICC, the International Criminal Court Statute, the Rome Statute of the court. And we signed the statute back in 1999, October. We have certain developments after this signature. Of course, we have the Constitutional Court deciding on the unconstitutionality of the statute, declaring that the statute is unconstitutional and contradicting the Constitution in two grounds. The first ground is the principle of complementarity, which is in contradiction with the certain article provisions that are dealing with the overall structure of the judicial system, and not allowing, according to the court, to complement the judicial system with a new instance. And the second ground for unconstitutionality was the rights of the sentenced persons for amnesty and pardon, as prescribed by the Constitution, and the court considered that it is unconstitutional to depriving them of the right there, because it's deprived them, the statute actually deprives them of the right to amnesty and pardon, because the statute prohibits amnesties for the crimes subject matter jurisdiction of the court, meaning the court crimes against humanity, war crimes, genocide, and now also the aggression. So this is the setting, and this is the context in which Armenia operates now. We are signatory with a decision by the court on the constitutionality issue. So if the court, if a decision is being made to move forward with the recognizing jurisdiction of the court or ratifying the statute, we need to deal with this issue, with the issue of constitutionality, because we need to at least the Constitutional Court needs to re-examine the statute in terms of constitutionality again, if not more than that, because it depends on the context. It depends on whether we would need new additional constitutional changes, or whether the constitutional amendments or reforms that have the country has undergone after the said decision in 2005 and 2015 are alleviating this unconstitutionality issues or not. So it's subject to qualifications be given by the court.
So I also want to ask about the European Court of Human Rights,
Sure.
Applications and interim measure requests. Firstly, what is the difference between the two? And can you explain to our watchers a bit about the progress with regards to what's happening at the European Court of Human Rights?
The difference between the two procedures, meaning interim measure requests and the applications, are the interim measure requests are usually filed when we are requesting the court to act urgently, meaning that because the consideration of the case in full on merits takes years until the court adjudicates the case and renders a judgment and decides whether there is a violation of a certain provision or provisions of the convention or not. But before that, so that we are sure that the respondent state or respondent government will be in compliance with the certain provisions of the convention, we apply to the court and asking the court for interim measures and requesting specific measures, for example, to refrain from any bodily harm with respect to captives of Armenian ethnic origin, or to respect the provisions of the European Convention during the wartime, and etc. and so forth. So those are the urgent measures when we request, and I think the public has been quite, I think we have been using this term interim measures quite a lot in the past couple of years, because we have been requesting interim measures, I think almost in every case when we had new Armenian ethnic Armenian captives. And at the same time, the application means that we're submitting a full application. In that case, in a specific case, meaning that we are presenting the legal document to the court based on which the court is going to consider our case, the document along with the evidentiary materials. And that's the difference between the two. And with regard to where we are now in the court, there are like several procedures ongoing at the European Court of Human Rights. We have 4 separate legal proceedings against Azerbaijan at the court. We have 1 more against Turkey, which is ongoing too. And of course, we have 1 application by Azerbaijan against Armenia too, relating to more or less similarly the same fact pattern, but with different emphasis, because their application also somehow brings up the issue relating to the First Artsakh War, and some issues relating to incidents that happened back in July 2020. And at this point in time, we are, I think, in the case Armenia versus Azerbaijan #1, which relates to the 44-day war and the immediate aftermath of the war. We are quite advanced there, because at this point we're now submitting our reply to Azerbaijan's response to our application, and we're doing the same with regard to their application, the written procedures. I think we'll be concluding the written procedures pretty soon, and that means that we might be having oral hearings in Strasbourg next year relating to Armenia versus Azerbaijan #1. And on the issues relating to the admissibility and jurisdiction in that case. That's 1 case, and we have like 3 more, which are relating to different scopes. 1 is relating to the sham trials in Baku with regard to Armenian captives. The other relates to the incident and our presence of Azerbaijani troops on sovereign Armenian territory, and the violations that are happening as a consequence of those incidents, and also that includes the September aggression too. And we have another application which relates to Artsakh, specifically relating to the events in early March, mid-March, the gas supply disruptions, and events of the relating to Paruch and Karakluch, and then continuing on to the events of August around Lachin corridor and Ahavno villages, which are also part of that application. So this is in a nutshell what's happening at the court.
And the main focus, as I understand it, well, some of the focus is on the International Convention for the elimination of all forms of racial discrimination in the international.
That's the International Court of Justice.
In the International Court of Justice. I want to understand, how do Armenian legal teams, how does the approach differ between the European Court of Human Rights and the International Court of Justice?
The approaches are, I think in this instance, more or less we're dealing with the same evidentiary materials, or more or less the similarly evidentiary, because the incidents that we're examining were presented in both proceedings, in both courts, because they are more or less identical, but the emphasis is different, because in the case of the Convention on the Elimination of All Forms of Racial Discrimination, the important point here is the motive of the violations being committed, meaning the racist motive and also anti-Armenian sentiments that are there, and I think most of the violations that we are witnessing have this racist motive that being committed there, meaning that the policy towards against Armenians and the policy of the annihilation of Armenians, or spreading the hatred with regard to and with respect to Armenians, is so pervasive and is so widespread in Azerbaijan. So I think any violation is linked to this overall environment of racism inside the country. So at the other court, in the International Court of Justice, we are now working on our main submission. That's the memorial, which will be submitted to the court in late January next year, in 2023.
And you kind of spoke a bit about this in a previous answer, but how does the Azerbaijani legal teams operate? Many observers say that the Azerbaijani legal teams are almost attempting to mirror the Armenian legal teams. Well, what do we mean when we say that, when we say they're mirroring?
They are. We have witnessed that in a number of times, because one of the maybe most flagrant examples of that is the reaction or retaliation by Azerbaijan when Armenia submitted its claims last year at the International Court of Justice. A week later from our submission, we received a reaction from Azerbaijan, a mirroring claim, trying to create maybe a false equilibrium, and trying to create a seeming impression for the international community that Azerbaijan is the true victim here. So that's what we mean when we're saying the mirroring tactics. And I think that also is somewhat present the proceedings in the European Court of Human Rights too.
Is it almost to muddy the waters, to make it more unclear to observers?
I think it is. Yeah, that's. I think among many things, that's one of the main purposes I think that they're trying to achieve, because it's important that because when you are starting, especially when you are starting a proceeding at the International Court of Justice, for example, which was public and was widely broadcasted across the globe, and the Armenian team presented the claims. Of course, they rushed to bring their own application so that they are able to somehow control what is being messaged to the international community. Yes.
And finally, I just want to ask: other observers have said that the Armenian side almost has substantial evidence when it comes to these cases, and in fact, the ICJ granted several requests from the Armenian side with regards to the destruction of cultural heritage, POW's issue. Can you tell us a bit more about that?
Of course.
Is that not the case when it comes to the Azerbaijani legal teams when they come to these international courts?
No, it's not. It's quite different. It's quite different because we don't. Of course, if we are speaking, for example, about the International Court of Justice proceedings, we have completely different stories, because what we received in the form of an order by the court in December 2021 was completely different story, because we. As you mentioned, the court indicated in its order measures relating to the preservation of the rights of the ethnic Armenian captives, with regard to preservation of Armenian cultural monuments, cultural property on the territories under the control of Azerbaijan. And also we have received, the court also ordered Azerbaijan to terminate the racist rhetoric and racist propaganda through its public institutions and public officials. And all of these measures that have been identified by the court and adopted in a form of an order, they are based on the evidentiary, like extensive evidentiary materials presented to the court, and of course rebutted, or at least the Azerbaijan presented its rebuttals to these evidentiary materials and pleadings of the Armenian legal team. But nevertheless, the court went on and concluded in its order and applied those measures, and that means a lot, I think. And we got and the vice versa. And on the other side, we have the Azerbaijani request against Armenia, asking the court to grant provisional measures. And the topic that they were targeting was they were trying to apply the Convention on Elimination of All Forms of Racial Discrimination to the mining and the minefield maps, which I think, and also the court agreed with our interpretation, falls completely outside the scope of this convention, and which is true. And in any case, I think it was quite evident in The Hague when we were presenting our arguments orally. So yes, it's a completely different story. And one more thing that is important, that we also, the most recent development in this regard is that after the attack of Azerbaijan on the Armenian sovereign territory in September this year, we and because we received, we started we had these captives again and POWs being captured in the result of this armed aggression. We requested the court to apply, to modify the measure, to modify the order applied back in December 7, 2021. And we presented the arguments, among other things, asking the court to extend the order and to modify and then extend the order, and saying that although at the moment that the court, we were presenting the arguments to the court and more additional documentation, the repatriation happened of the new captive POWs, but we still insisted on our request, considering that since Azerbaijani troops are continuing to be placed on sovereign Armenian territory, the risk of the new captives is quite high. It remains high. And we insisted that the court still considers our request on modification. And of course, we received the decision of the court on that, in that regard on 12th October. And the court made the decision already public. The court actually formally didn't actually modify the order. They rejected the modification request, but the court gave a very valuable interpretation, which I think coincides with our understanding of the order. What the court said the following. The court said that the situation between Armenia and Azerbaijan persists, and the order of 7 December 2021 is applicable to the captives captured in the course of the escalation of and renewal of the armed conflict in September 2022, and any other captives onwards. So meaning that the court interpreted the order of the December 7, 2021 in the way that we were intending to and asking the court to do. So I think we could say that this is a positive development for Armenian side too. It's a win actually for Armenian side. So yeah.
Okay, well, Yeghishe Kirakosyan, thank you very much for your time.
Thank you.
And thank you for joining us on CivilNet.